Welcome back to another episode of Site Talk Exploring Construction. I'm your host, Zeher, aka the TikTok Inspector. And today we'll delve into a topic that is crucial for every homeowner and also a professional out there in the construction industry: understanding your rights before, during, and after construction. So we've received numerous questions from you guys, valued listeners, and today we've brought in a legal expert to answer them and spread awareness about the homeowner's rights. So joining us today is a highly esteemed figure in the field of law with a focus on construction and plumber's warranty, the founder of Bastion Legal, Dean. Welcome, Dean. Thanks for coming.
Thanks,
Appreciate it.
Thanks so much.
Thanks for coming today. So do you want to tell us a bit about your company, what exactly you do?
Sure. The firm was started with a focus on builder's warranty and plumber's warranty, so building disputes. And the firm deals with a lot of clients that have a lot of items in their homes that are not up to scratch. They're defective, they're not compliant, and they really don't know what to do. And so sometimes they've got a report from an expert such as yourself, and sometimes they don't. But we just guide them through the legal process and how to best prepare the claim. And if they did want to pursue legal action, then that's there for them as well.
Yeah. Oh yeah, cool. But it's very important to actually understand insurance and what rights the homeowners have. You know,
exactly. Yes.
For plumbers insurance, building insurance.
Yes.
There's a lot of homeowners when we do inspections, the homeowners go, "Oh, I've got building contents insurance," but the thing is, they don't realize that they've got another insurance.
Yes.
From the builder.
Correct. Yes. So, if the building works are more than 16 grand in a total, the builder must take out that form of insurance. It's called a domestic building insurance, or a builder's warranty insurance, and essentially, the builder must give some sort of evidence that they got that insurance when the contract is formed, and the client should hold that. They should know what that means, and that. Look, to some extent, it does protect the owner, but it also is mainly there to protect the builder. And that's because, unlike other forms of insurance, which we can go through, it only kicks in if the builder's dead or missing or bankrupt. If there is problems with the works, or if the works have stopped, or if there's defective works, you need to deal with the builder first, and they need to come back to try to rectify the actual issues. And if it doesn't go anywhere, if there's a halt on the actual dispute, or then the client or the owner need to then pursue the builder personally, which means they don't have any actual insurance if you go down the court process.
So basically, any works over $16,000, the builder is required to get this insurance. Because I've basically been in court like a couple of weeks ago, and the builder didn't get insurance. The job was over $300,000.
Okay.
And the builder didn't get any insurance. The homeowner didn't know it was a requirement to have this document. And apparently, I think it was in the news a couple of months ago, we're talking about bigger builders,
yes,
like volume builders and all that. Okay. They actually were starting the work without getting the insurance. And it happened to Port Davis as well.
Right.
A lot of homeowners, as you know, when they went bust, there was no insurance. They've actually started the works, and it was probably just maybe cash flow or something like that.
Okay.
And they weren't insured. So it's so important to anything over $16,000.
Yep.
You make sure you do have this document.
Correct.
And there is, in Victoria, as we all know, there's only two insurance companies, the VMIA and Asset Insurer. They're buddies. They're good friends. So the VMIA is from the government, isn't it?
Victorian. Yeah, it's a scheme that's there to protect the builder. But I guess what I want to just, make a point of is that, yes, it is there to protect, the owner of the actual dwelling, but it more protects the builder because, or to some, it just depends on how you actually look at it. But if I can just contrast with the plumber's warranty insurance, if you want to pursue the plumber for plumbing works that is not up to code, then You don't need to wait for the plumber to be dead, missing, or bankrupt. You can make a claim straight on their actual insurance company, right? Whereas with the builder, because they're still in the picture, unless they're dead, missing, or bankrupt, you need to pursue them, through a VCAT, through the DBDRV, through the courts, or whatever it is. And so the insurance doesn't mean anything unless those standards are not there. Yeah.
So you're telling me that recently on the news, the VMIA has increased their prices by 43%, and so basically they do. Let's just say they do have the insurance right now. They've got it, But the thing is, and there's non-compliant works everywhere.
Yeah.
There's roofing defects, for example, or there's waterproofing, structural defects. They can't access that insurance, which they already have got, unless the builder has died, went bankrupt, or disappeared.
Or is correct.
So so the insurance only gets triggered until one of those conditions gets activated. Is
that's exactly right? Yeah. So it gets triggered. That's the actual language. Yeah, and it's really just there as a backup. So the scheme is really designed that the builder is there to deal with the mess that they've made, pretty much. And even if they had hired other trades to come in and do, say, the concreting, the tiling, or whatever, it mainly does fall on the builder. We can go through that a bit later on. But essentially, the scheme is designed that the builder is the one to actually pay the claim out or to fix the actual defects.
So you got to chase him legally.
Yes,
you can't force. You can't basically go to the insurance.
Force them to go bust. So
the builder. What about the builder? The builder can't even use it. So you're saying the homeowner's got this insurance and is happy with it to protect him, and then you've got the builder who's hey man, the homeowner tells him I've got defects, whatever. The builder, one of my episodes of body cam footage, you see me talking to a builder. I saying, hey man, you got non-compliant works in the bathroom here and there. You got the water stop non-compliant. You got to demo the bathroom, and they're like, oh yeah, I'll just pay the excess and use my insurance. Yeah, you can tell them that, but I'm saying you can't use the insurance. No. Yeah, no one can use it.
Yeah. Whose insurance?
The builder's insurance.
It is insurance, of course. I can't use it.
Yeah. I'm saying you can't use it.
If I put towards my insurance, then I'm going to be paying the excess.
You can't access it.
Yeah.
And this is a builder who, and that's why I wanted to do this episode, because even builders don't even know how this insurance work. They think that they have to pay in excess and to use the VMI insurance. I said, you can't even use the insurance. You got to actually pay out of your own pocket to fix it.
Correct.
Or the homeowner's going to take you to court. So basically, the homeowner can't use it.
Yeah.
The builder can't use it.
So no one can use it. So so they've got a document there that the owner doesn't even know what it means some of the times. The builder doesn't know what it means.
Yeah.
And we can't even use this actual insurance unless the builder is dead, missing, or bankrupt. So it really isn't used all that much when you really think about it, because all these things got to come together for it to be used. Yeah.
And basically, look, I'm going to play this video from the VMIA.
Okay. Is mandatory cover protecting homeowners in the event their building project cannot be completed or has defective works which cannot be rectified.
Sounds good. Okay.
Become insolvent.
See, they even say it as well.
Issued by VMIA on or after the 1st of July 2015, DBI also provides cover for homeowners where their builder has failed to comply with a tribunal or court order.
All right, so basically you've got these 4 triggers, and they're even saying it. They say, hey, look, we've got insurance, great news, but you got to satisfy one of those conditions.
Yeah, it's a last resort.
Last resort kind of thing.
Yeah, it's not there front and center.
Yeah.
Because a lot of people don't know it's there, and even if they do know it's there, they can't really make the builder go bust, and they're not going to kill the builder. So it's really just there as a last resort.
So I want to talk about all right, now that we know what the hell it is, I want to talk about also the period of cover between the insurance and the builder and the roof plumbers. So we've got the VMIA provides a period for non-structural defects, and we'll talk about what non-structural defects are, for 2 years, and for structural defects 6 years. That's
So the cover is it's for non-structural. It's 2 years after the completion after completion of the job or when the building contract is over. And it's 6 years from the date that the job is over or from when the building contract is over. So that's the time frame that you've got. For plumber's warranty insurance, it's 6 years from the compliance document that the plumber gives you when they lodge that. You'll see on page 2 or maybe page 1, just at the very end of the actual document, you'll say date lodged. You count 6 years from that date, and you've got 6 years to notify the plumber insurer that you want to bring a claim. It doesn't mean you have to start a court process. It just means you need to notify the plumber insurer, before there's 6 years. And I'm not aware of any extensions on that, so it is strict. And
but that don't need to be like it gets triggered whenever there's non-compliant works or defects. It doesn't have to they don't have to wait until he dies, goes bankrupt, disappears.
No, exactly right. So like if the plumber is still kicking and they're still doing work and they're still around, doesn't matter. They can either the plumber can make the insurance claim or the owner or the client can actually write to the insurer in a certain form and put them on notice that they're actually going to bring a claim. But that notice time, notice that they give to the insurer, it's got to be done within 6 years of the compliance document. If a compliance document is not given, it's 6 years after the work stopped.
So how is that fair? I mean, the plumbers, to me, the plumbers have it easy and the builder's carrying this burden. But the thing is, the builder has not only, the plumber's got 6 years, but the builder has 10-year liability under the Building Act.
Plumber and builder,
they both got.
Yeah. So,
but in terms of insurance, insurance is 6 years for the plumber and 6 years for the builder as well through VMIA.
So
but for personally liable.
Yeah, so for your structural issues, for the builder, you've got 6 years,
6
right?
years,
Now the plumber, it's 6 years, I guess, as a general rule. Now the Building Act says for defect claims, you've got 10 years, right, to actually bring a claim. And there's certain rules about when the 10 years starts, but essentially, let's just say the actual insurance that we're dealing with is only a 6 year limit, right? You got a balance of 4 years that the owner still has to bring a claim, right? So they might see the actual defect later, they might not get around to it, or they might not know their rights or whatever it is, and so they might, it might tick over from the 6 years of when they had to claim on the actual insurance. So they still have a claim against the plumber or the builder under those two, I guess, systems, but there won't be any form of insurance there. So you have to
they can't use the insurance after the 6 years.
No, they can't.
They can still sue
They can still sue the person or the party. Up to the 10-year period, but that last 4 years of the actual sequence, there is no insurance there. Whether they're dead or missing, it doesn't matter. So there is no. So it's a lot harder to sue someone in the courts and things like that if there's no insurance there. So it's a lot more risk for the owner to leave it over the 6 years, and so there is a gap there in between the scheme and how the Building Act works. I think it's got to be addressed, but it's not yet. So we don't know how it's going to go, but people should know that, it's a lot better to have an insurer at the end of the tail than to actually wait till that,
because how is that fair? I mean, the builder's paying the VMIA and asset insurer a large amount of money to get this insurance. No one can use it. And then not only that, after 6 years is over, the builder is still liable for this. For 10 years, the builder's liable, the plumber's liable for 10 years personally.
Yes, correct. Correct, yes. Yes.
And also, from what I know, is that the VMIA also holds the builder personally liable. So if the VMIA, for example, goes and rectifies a job, they can chase the builder personally. What the hell is that? How is that insurance, man?
Yeah, exactly.
It's not fair.
Yeah, it's really.
I mean, I pay insurance to protect me, and then I'm paying for this guy to protect me, and then sue me.
It's like me saying, you go driving the road and you hit someone, and the actual insurance that you pay premium every year won't help you unless you're dead missing or bankrupt or whatever. You know what I mean? So it's really doesn't make a lot of sense. Yeah.
And you know what? No one talks about it, and it's been there for a long time, and it's really not fair.
I feel for the trades as well, because they should have some form of insurance there that will cover defects, right? Because they might have other sort of insurances that might not cover actual defects. They might cover specific events like storms and fires and that sort of thing. But with actual defects, they are sort of exposed, I guess, on a personal basis once the 6 years is over. So that's not good for them. And also there was a decision in the courts that said that even if the defects were discovered after the 10-year period, it didn't matter that the owner only has 10 years to bring the claim. And so if the cracks or whatever they're finding it comes later, and they get all these expert evidence to say that yes, the defect is causing all this, it doesn't, they may struggle to bring a claim
under the Building Act
after the 10 years is done and dusted.
Under the Building Act 1993, and we'll put an extract as well. We know that we've got the builder who's got insurance, the plumber's got insurance, electrician's got insurance, the building surveyor. It's a requirement for those guys to have insurance.
Correct.
But your painter, waterproofer, tiler, cladding guy, concreter, those people, they've got no insurance.
Well, potentially they've got no insurance.
And it's not a requirement.
Well, no. The actual VBA site that has all the classes of sort of insurance, they're not listed there, so it's not, I don't think they'll really get in trouble if they don't have insurance. They're not registered is the main thing, they're not required to be actually registered on any register at all, so there's really difficult, it's really difficult to keep them accountable for what they've done, because they aren't registered on a specific list. And that's why a lot of this blame falls on the builder, So they engage them to come, fine.
For 10
they're the head
years.
contractor. Yeah, exactly. Yeah, so they have to basically, there's a lot of stress on the builder, to actually make sure that all the works are done properly. And to get qualified tradesmen in and, and people that will do a good job, because, the buck stops with the builder. Basically, they're the first on the chopping block to really be called to to actually pay out a claim.
I want to ask you a question. All the skilled workers that Dan's bringing from overseas, do you think he's got insurance for him, or when they do the work, like the bricklayers that come in from overseas and all that? I mean, and the tilers, I mean, they're going to come, obviously I'm assuming they're not going to know the Australian standards of work, which is the minimum standards. And basically, he's bringing them from overseas, and then they're going to undertake non-compliant works. And guess what? Who's liable for that? The builder's liable.
Yeah.
Because they've got no insurance.
Because of the way the actual system is, exactly like the way that, I guess, the courts generally work, and the fact that those trades won't be registered, because they're not the main trades, they're not the plumber, the builder, or the sparky. So, the tilers and the concreters and that are just coming in.
So he has to basically look over their shoulders like every step of the way. You have to actually watch them.
Yeah, exactly. And I think what's happening at the moment as well is that a lot of builders, because of I guess of how hard it is now, because of the labour short, I guess it's really difficult to actually get workers now, and the cost of materials have gone up and all that. That there's not a lot of oversight of the actual builder on the side as well, on the actual building site. So they're not there a lot of the time. They're not seeing what's going on. They don't supervise that much. And some of them don't even have a trade background, like the builder has a license and things like that, fine, but sometimes they don't always have a trade background. And so they're not seeing a lot of the work that's going on. They're just hoping, or they're just trusting the actual trade that isn't registered, is what we're saying, or may not be registered, to do the job properly, and that's why a lot of the time it's a bit of a cocktail, that goes badly.
So like if there is a trade on site, I'm just going to say like the waterproofer. He's got no insurance, did non-compliant works, and the homeowners moved in, water leak in the bathroom. They contact the builder. The builder will say, hey, man, it's the waterproofer. Here's his number. Go chase him up. I mean, he's got no insurance, nothing. They got to chase him personally. All right. But the thing is, I know the Australian Consumer Law, Section 60, I've got a clause there. It says, if a person supplies in trade or commerce services to a consumer, there is a guarantee that service will be rendered with due care and skill. If this guy didn't care about the job with no skill or whatever, I mean, to activate this clause there, they have to take this guy to court.
Yeah, exactly.
They can't access the insurance because he's got no insurance.
Exactly.
So the homeowner has to go to the builder, drag him to court. He has to defend himself in court. Minimum $50,000 to just defend yourself, even though it's not your fault. can't access the insurance. The industry is just stuffed at the moment, man.
Yeah, it's just that a lot of the, I guess, the pressure and who's liable for things falls on the builder. Because I guess to one extent they did engage that person to come in and do the job, but at the end of the day, they didn't actually do the defective works. It's someone else that did it, and instead of having a system where the people that actually did the job, in the wrong way, are called to account. That's not how it works, because they're not really accountable. They're not registered. They may not have insurance. You know what I mean? And even if they did have insurance, the other question you would need to ask is because they're not actually registered on a list or a special register. How do you know who their insurance is with? Yeah. That's the other thing. So even if they had some sort of insurance, let's say they've got they have some sort of policy. How are you going to find out unless they tell you, Whereas with, say...
They just want to answer your emails or your calls, nothing.
Well, with the builder, as we said at the start, is that they need to have that...
Before starting.
They need to give that evidence that they've got the insurance there and they give it to the owner, right? That says what it covers, when it starts, all that stuff, right? And who the actual insurer is. With plumber... you can actually do a claim on the VBA, which that will give you the plumber's insurance details. So like with who they actually had the policy with every year, because there's various plumber's insurers out there. But with your concrete or your tiler, it's just like a guessing game. Like even if they had, if it's a big if they had insurance, like how do you find out? Like who the actual insurer is?
So the requirement for insurance, if it is to happen for those trades that have no insurance, it has to be regulated by, let's just say, the VBA. Like there has to be an authority that say, hey man, these are the trades, these are the guys that have to have insurance before starting the work. And if the work's is more than 20 grand, for example, we'll just figure out there. You got to have that insurance. If it's under that, you don't have to have. So they have to, start doing something about it.
Yeah, look, they've been talking about it for years and years, and nothing's changed.
Mate, and the painter, I reckon. Look, in my opinion, the painters are making more money than the builder. You know why? No liability. They do 10, 20 grand, 5 grand, 10, 20 grand a job, killing it.
And they go zip, and then like
never see him again. Man, can you come back fix the job? Yeah, we'll just, do your best and paint the rest. For one of the roof plumbing cases, what's the most that you've got back from an insurance, from a claim, or you don't want to say that?
Look, it's, it can be a fair bit, it can be...
Like basically, if the whole, I'm assuming there's going to be scaffolding involved, the owner has to move out. Do these things get added to the claim?
Yes.
And what about the legal cost and the and the report cost that the homeowner is getting? Can you claim that as part of the insurance claim?
Yeah, you can. Yeah, so the claim, is roughly up to $5 million into what you can claim, and that does cover your legal costs and expenses. So that means your lawyer fees and expenses would be your expert evidence, like someone like you coming out and doing a report. It covers that. It covers, if you need to go and rent somewhere while they actually while they do whatever they've got to do. If you can't live there, then your rents and things like that. Make safe works, some of the building works that you got to do, even if it's not plumbing related, right? If there's a plumbing defect, but you got to come back and do carpentry to fix it or whatever, all that is potentially covered into it. But that's all that. Now with some of this, because a lot of plumbers matters don't actually get to court or to VCAT, some of it is not, a lot of it is not really tested, and so how much it, it can really come to will really depend on case by case, but essentially, there's a lot that it covers. It's and there is a certain clause in the actual order that governs the whole plumber's insurance scheme that says that your legal costs and expenses are covered by the order. Now that's in there. It's I don't really believe it's been tested yet, but it definitely is there, and it is broken down in the claim that we do against the insurer. So we say this is the cost of fixing the job, this is our consequential losses, this is what we've spent on expert evidence, these are our lawyers' fees, it's within the claim that we claim on the insurer.
How on average, how long would a claim take? Like on average, like what, 1 month, 2 months, a year?
Nah, look, it is longer than that. It could be a year. It could be months, but
what's the best case you've ever had?
Best case. It really depends on how prepared the client is before they come to me as well, you know. So essentially, if they've got like a lot of their expert evidence, they've got an engineer, they've got all this,
already.
you know, it could be a few months where, you know, we get a reasonable offer and that's it. But like, that's not very likely.
Yeah.
Insurers aren't going to just roll over and, you know, pay you what they should pay. A lot of the times, a lot of the fights will happen based on quantum. So like how much the case is worth, you know. So we say it's worth a certain amount. We back it up with the scope of works and get it, you know, quantified and things like that. But essentially, I mean, if you get into the actual VCAD system or even the courts, you know, that's going to be a long delay.
Sure.
It can take years, you know, it can really take years. But your best bet is to prepare the claim as best as that you can, so that you know you do have a better chance of trying to resolve it early.
Now this is for roofing, but the thing is for building. I'm looking at the VMI policy document right here.
Yes,
and it's clause 37, section 37. It says we will not pay more than $300,000 in total in the aggregate for all claims under this policy and expenses that you incur associated with successful claim against us. So the thing is, they'll pay legal costs and expenses that you incur. That's part of the $300,000, but that's for each home, isn't it? So if you've got like four units, that's $300,000 each, up to $300,000, sorry, each.
Potentially, yes. So at the very start of the contract, you need if there's 4 units, it's got to be 4 of those documents that you get.
Oh, okay.
From the actual, so make sure you get 4 separate documents that says, you know, for 1A Smith Street or whatever it is, you know, smart, and then 1B whatever. So you want to make sure that it's all there.
I want to just show you quickly. I've actually done last December. I've done this report for. It was for Pivot Homes, but the homeowner engaged me to do an inspection. Builder went bust. There's water leaks everywhere. Non-compliant roofing works. Non-compliant everything. The whole house is just stuffed. So I did a big report. They sent it to the insurance. I'm not going to say which one, A or B, but it's one of them. And they got a loss adjuster.
Loss adjuster.
So they got this guy to come through, and he's like, no, this is not a defect. And I actually did a video about this, but I'm going to do another video about it. But this guy goes, this issue is of a non-structural nature and in consideration of the fact that the day of this claim is some 3 years and 5 months following the issuing the certificate of occupancy permit, the 2-year policy period in respect of non-structural defects has already lapsed. So these guys were trying to get out of it, stating that there is non-compliant works. We confirm there's non-compliant works, but there is no damage yet. So there is the water stop. I'm looking at it. I go, hey man, this water stop is non-compliant. Yeah, but he goes, but there's no damage yet. So we're not gonna
cover you.
We're not gonna cover you. So when I did a video in response to that, these guys, they got another guy to come in, another inspector from subcontractor, and then he came in and he's like, yep, he accepted everything except the landscaping and driveways and stuff that's not covered under the policy, but I'll put it in anyway. But they accepted everything. You know, I mean, these guys, like when the homeowner goes to the insurance company with like, for example, my report, and they go on their own, the insurance companies, man, they're big players. They know how to play the game. They'll knock them back straight away.
That's right. Yeah. So it really does help to, you know, get someone like you that can go do like an expert report and look at certain things and to get legal advice at a certain point, because, you know, that is one example that if the owner or the client just, you know, listened to what the first response was, that they would have lost out.
Oh yeah.
So like, you know, you do see that a lot. And a lot of these provisions are grey, but, you know, an example like that, it sounds like it should have clearly been covered, you know, and you know that.
And how come they do that? It's just unfair for the homeowner. So instead of being, you know, transparent, hey, the builder paid your fee, the 43% increase of the fee, whatever, you've actually got paid for your job, and you're knocking back the homeowner. So now the homeowner has to engage a lawyer. You know, to help the fight.
And it's not fair for the owner to actually go to that trouble and expense and everything of getting a lawyer or like an expert or whatever it is. It should be just, you know, this is what the claim is and that's it.
Yeah, why are they playing this game? It says, whilst it is acknowledged that the paint finish applied to the top and bottom of the windows do not have some number of coats, whatever. They're saying, you know, it's not considered a structural defect. But the thing is that they're saying that, like, if I look at their policy, I'm going to bring the policy up right now and see what they say about it. Actually.
Yeah, and just while you do that, I mean, what people should know as well is that a lot of these insurers do sign up to the insurance code of practice, and so if they're a signatory to that insurance code of practice, there are different rules that that governs the claims handling that the insurers are really meant to be doing, and one of them is being honest. They're meant to be timely. They're meant to do it in a fair way. And,
so can you do the claim? Can you actually get the claim and actually sue them for stuffing you around? Come on, man! I want to go all out on these guys. So
look,
you know
can
what?
Definitely frame it that way, but you want the actual defect as well. So
Look, I'm reading the policy here, and I've actually highlighted that section from the policy. I sent it to the homeowners. I say, hey man, look, I'm actually going to do a video about this, but also just look at this. It says structural defect in relation to a dwelling means any defect in a structural element of the dwelling that is attributed to defective design, defective or faulty workmanship, or defective materials. Now here it says, this is the most important, results in or is likely to result in the dwelling or part of the dwelling be required under the law to be closed, prohibited from being used, prevents or likely to prevent the discontinued practical use of the dwelling. So I'm not going to read the whole thing, but the extract's going to be there. Is likely. So when I see this defect inside the home, non-compliant, it's only 3 years old. But on the 9th year, it might happen. And then on the 7th year, it might happen, and you're not covered by the insurance anymore. Builder's gone. And the insurance,
there's no one.
And there's no one. So these guys are trying to get out of it. And in their policy, it says likely to. And that's what pisses me off a lot, man. Like, your policy's right there. And I'm telling you, as soon as I got this response, within like a couple of hours, I did the video. And then they sent this guy again. And then those same sections that were denying, they've written a scope of works for every single section, and I'll put the extract for that as well.
Well, yeah.
I just can't believe it, man.
Well, yeah, no, it's just,
if it wasn't for me doing that video and for the homeowner fighting back and doing that, man, they would have accepted what they said, and you've got 14 days to accept, or else everything gets gone.
So there's like time pressures and things like that. Another thing that people should know as well is that I think from around 2021. ASIC has come into the picture, and so what's happened then is that claims handling, which means just the management of the claim, is now a product that ASIC has overview of. So if clients think that they're being lied to, if insurers are just taking their time and dragging out claims and making them making clients tired and things like that, so they just give up. If there's certain breaches there that they think that the insurers are doing, they can actually make a complaint to ASIC and get ASIC to look into it to see if that's actually valid or not. And so and ASIC have wide ranging powers. They can issue fines, they can take away the license of the insurer, if it's really serious. So like it's serious stuff. It's not just
even
slapping
though
the wrist.
Even though the VMIA is a Victorian managed insurance, that like government versus. They can still do it,
Well, look, it is a new area, because it's so new. Because we're only into like the second year of it, or not. Like I don't believe that there's actually been like some sort of a court action with sort of a claims handling service. But I mean, it is a claims handling product. If clients do want to go down there, they should seek legal advice.
Yeah, all right, no, appreciate that, man. I love using this document, the Domestic Building Contracts Act 1995. Yeah, it's got so many good pointers out there, and I always tell homeowners, they send us some questions and we say, hey, go to this clause and have a look at it before going to a lawyer. But it's such a good document. Like, for example, it's got, we're going to go for a couple of them, and it will help homeowners and builders to know what the hell's going on. We'll go for the first section here. I've got Division 2, Section 11, limit on amount of deposit. Now, this is so important for homeowners to know. If the contract price is more than $20,000, the builder can't ask for more than 5%. All right. If the contract price is less than $20,000, 10% max deposit they should ask. So if you get a builder saying, hey, for $100,000 job, and they say, give me 50% deposit, that's something trouble. That's in breach of this act, and there was actually a court case that you sent me through, where this guy here, and I'll put the link on the video as well. It's where is it? Lee versus Caliber Built Developments Pty Ltd.
Yes.
Now, if I go to the last page of that,
Yes. So essentially, with this case, what happened was that a building contract was formed, deposit was paid for the reasons that we won't go into here.
Yeah.
There was, the works didn't start. The builder went ahead and actually paid for things, so, the fence height, the toilets, things like that. And essentially what the member here said is that they referred to Section 11 and said that, the builder's the margin of the builder doesn't apply to the deposit that was paid. And it does enforce the fact that, it's only 5% of the contract price.
and they also state that, it says there, this guy charged 15% margin on the deposit. So he's got he did the right thing, 5% deposit.
Yeah.
But then he charged 15% on top of that to claim more money.
So, like, when these disputes happen, it's like, what the member or what the judge will look at is, what does the contract say, right?
Yeah.
Now, there's implied terms to every contract, and implied terms are, terms that are put in the actual act, So, like, so that section that you just read out, that's an implied term to some extent, because it's a contract is not higher than what the law is, So contracts are there to govern the dealing between the client and the builder, but there's certain implied terms that are implied into those contracts too. And so what the member there said is that not only was there not an entitlement to claim the margin, but also she did refer to Section 11. And she says that she did enforce the fact that it's only 5% of the actual contract price with respect to the deposit paid.
So this just shows that when something goes to court, the judges will refer to this act and say, hey, the act specifies no more than 5% deposit, and you've actually got more than 5% deposit, which is...
And also, and she's also said that even if there was a special condition in the actual building contract, because you know how sometimes you can handwrite
a special condition,
even if it said something different, it wouldn't be valid because Section 11 says what it says.
So that overrides it, no matter what you're saying in the special condition.
Exactly.
You can't just say, hey, man, even though the act states 5%, I'm going to ask for 20%. Sign here, please, and they sign it.
It's not like that,
It's not the right thing to do.
No, it's not. No, so it's not ethical for the builder to do that. It shows that they don't know what the law is, and also, the member here has said quite clearly that even there was no contractual entitlement to do what the builder wanted to do, and even if there was some special condition that said what the builder wanted to do, that it wouldn't be valid by virtue of Section 11.
And it actually states here, the builder referred to a special condition in the contract which entitles them to charge 15% margin on extra work. They applied this 15% margin to the deposit and claimed to be entitled to retain $3,203. But the thing is, it actually states here, and then it goes, the builder interpretation of the contract is incorrect. She said that.
She said that, exactly,
So now let's go back to the Domestic Building Contracts Act. Now we go to, as well, this is the same thing as well, which is another breach. The builder must not seek, this is Section 16, sorry.
Yes.
Builder must not seek more than the contract price. A builder who enters into a domestic building contract must not demand, recover, or retain more than the building owner an amount of money under the contract in excess of the contract price unless authorized to do so. And it's actually 100 penalty units. That's nearly $19,000.
Yep.
A lot of money, man.
It is.
If he breaches that. And as well, I mean, if we go to that same court case, he actually claimed more than that. But I want to ask you a question. Why didn't the member apply this 100 penalty unit? Like, I know, when does that get activated?
It's discretionary, So, these things are there for the member or the judge to really apply that, And in this particular case that we just discussed, there were certain things that the member ruled in favour of the builder. So they're not one-eyed. They're not going to say yes, the owner's right on everything. They're going to look at specific claims that are made throughout the case. So in this case, there were costs for the site cut, the fence hire, the toilet, the builder's time for doing what he did, in like organising everything. Some of those things were actually claimable by the builder. Like there were some things like, say for example, the fence hire. The builder went and hired it for a certain amount of time, right? And the owner said that they could have transferred the actual 12 months into the owner's name so that they could make use of it. And the member said, no, that's not really reasonable. It's not for the builder to actually do that. They were on the assumption they were going to start the work. And also, even if they made those steps and tried to transfer that lease into the owner's name, the fencing people, there's no guarantee that they would have even done that. You know what I mean? So because there was some wins for the builder, some wins for the owner. I think the owners won more, but at the end of the day, it's a bit of a weighing up of the scales and to see.
But the thing is, from what you're telling me, is that the member was lenient and she didn't basically use the full force of the penalty units. Like she could have said, "Hey man, 100 penalty units, sorry." Even though that you've done those things, and we're going to settle at X amount, you still got to pay the 100 penalty units.
Yeah,
they didn't do it.
Look, they didn't do it. Sometimes
they don't have to. Yeah.
Sometimes these penalty units, is there for perhaps a regulator to sort of step in and
if they go to the VBA or something like that.
Maybe, things like that. So it's not, a lot of the times. They will just want to deal with the matter at hand and to try to resolve it as just as they can, as fair as they can.
The next one is something that I love to use, and this is I basically got a screenshot on my favorites folder on my phone. I just send it to all my clients. Section 19, access to building site. A builder must permit the building owner or a person authorized by the building owner, can be your next door neighbor, to have reasonable access to the building site and view any part of the works, any part of the building works. 20 penalty units if the builder says, nah, stuff here, man. $3,846 he has to pay. But the thing is, authorized person, what does that mean?
So look, if the owner actually nominates someone to act on their behalf, and they've got that authority, so it could be someone.
No qualifications.
No, they don't.
Does that have to be like an architect or like a registered builder or inspector?
No.
Nothing.
It can be someone that they actually just nominate. Yeah.
And reasonable access to the building site. Basically, what is that? Weekly, monthly, or what's like reasonable? You reckon
that can vary? I mean, if there's safety concerns of going on the site, that's a factor they will look at. You know what I mean?
Okay.
It does depend on at what stage of the build it is and things like that. But obviously, if there's a repeated attempt to go onto the site and
every day or something
the builder
like that,
is saying
weekly.
No, well then there might be like an argument about that. But they've put this in here for a certain reason. Because the owner, I mean, look, to some extent. The builder has authority over that site to the extent of, they're organising the works and things like that. The land, though, is still owned by the owner, right? So, that's there because, there have been some matters where there have been disputes about that, so
I see it all the time.
Crystallise that, yeah.
We see it all the time.
Okay.
The builder says, no, sorry, you can't get someone unless they're a building surveyor or unless no one's going to come, no one's allowed to come on site, to inspect the work. Like reasonable, in my opinion, is like at least each stage, base stage, frame stage, when the slab's down, come and have a look. When the frame is up, come and have a look and let me know what you reckon. Lockup is done. Before you pay the work, like for example, I got another video for a Snowden job, which they went bust last year as well, the builder Snowden. And these guys, the builder sent a progress payment to the homeowner and then they sent pictures that the job's done, but they sent certain angles and certain sections and the lockup wasn't complete,
right?
But they still paid all lockup and then they went bust.
Yeah, okay.
You know what I mean? And these guys didn't go see the job, they just sent them pictures. So you got to be really, really careful before you pay it. Like, what do you reckon? Before you pay it, the builder, shouldn't you go inspect the work?
Yeah, I think you should. Because like, how do you know if things are getting done? Particularly at the end of the job, when the builder wants their final claim, and it's meant to be complete, like you should definitely go on that final inspection and do a proper inspection. You know, if you did want to get an expert in to just for that peace of mind to see if there's defects, things are not completed or whatever it is, because the contract is probably going to have some certain clause or some certain steps that need to be done. Like, so if there are some defects, you need to send the builder a list and things like that, and they're going to be signed. And so there's a waiting time as to when you need to give the builder for them to return.
Do you think, let's just say the builder says, hey man, I've finished the frame stage. Yeah? Here's your bill, pay me. If then I come in and have a look at the job, have a look at the job and the frame's not compliant, do you think that the homeowner should say, hey man, look, I'll trust you, bro. Here's your money. Yeah, but can you fix the defects? Or do you reckon, does the homeowner have the right to say, hey, here's the list of non-compliant works, even though the building surveyor signed it off. We see that all the time. Building surveyor signs off the job, non-compliant as per the drawings, non-compliant as per engineering, and to the Australian standards and national construction codes, and they still pass it. But then we come in and say, hey man, this is non-compliant.
Yeah.
So do you think the builder has the right to demand to spend works, demand payment, even though it's not complete? Because technically it's not complete because it's not compliant, isn't it right?
Yeah, it's hard how it all works, but essentially, you know, there are claims, especially with that, I guess, the final inspection, but like even when you were saying the stage, like certain stages, you know, on a contractual basis, I guess there is an argument to say that, you know, the payment should be given because the work was done, but you know, if there's defects there, and this isn't illegal advice, it's all dependent on the case, but you know, there is like an argument to say that, you know, the owner should demand that the job is fixed properly or done to code and without any defects before that payment is made, because then the pressure is really on the owner to chase the builder to actually fix everything once the payment's gone through.
Yeah, that's right. I mean, if the homeowner does pay, because it happened to, I forgot the builder, I think, Bentley Homes. They went bust earlier this year. We did an inspection, fixing stage inspection, and these guys were taking ages to rectify things. And I had a feeling that they're going to go bust.
Okay.
And then what happened is that we did a fixing stage inspection. The invoice amount was towards, I think, 200 grand, 200 something $1,000. I said to the homeowner, goes, hey, should I pay? And I go, look, if you pay today, just imagine the builder goes bust the next day, because you've got incomplete works, the waterproofing to the balcony, waterproofing to your bathroom is not compliant, roofing is not compliant. If you trust the builder, look, I can't tell what to do. But the thing is, these guys paid the builder, I think, on a Wednesday, and then Friday they went bust.
Well, okay.
And this is what I tell this is what I tell home. I mean, I tell them, hey, this is not legal advice. I say, but the thing is, just imagine if this was my home and there's all this incomplete works, non-compliant works, and then you pay the builder the money, hoping that he's going to fix it. You've actually paid for a defective product, a
basically, exactly right.
So why would you do that? I mean, does the builder look? I mean, we've got here this court case. The court case right here, it's a good example. It's Console versus MLE Homes, M.L.E Homes, P2O Ltd. Now, this builder went bust after this court case. And if we look at this section right here, it says here that, as noted above, fixing stage had manifestly not been completed. As such, the builder had no entitlement to demand full payment of fixing stage. Do you want to touch on that before I continue?
Sure. So, I mean, with the case that you've raised, I mean, it's a really good example that the builder didn't have a right to stop works in March of 2018, which is when what happened, and they stopped works because the owner didn't pay the 50% of the fixing stage payment, right? So like there was some dispute there, and like the owner said, I'm not paying, and the builder said, well, I'm not going to continue. The member in this case found that the builder didn't have that right. You know what I mean? So it's a cautionary tale that you really need to, I guess, know what you're paying for, you know, before you know, like you have to see what you're paying for, I guess, before you actually pay it. So because in this particular case, and like every case is different, but in this case, you know, the member said that the fixing stage was not reached, you know, and so that was a key finding in this particular case.
So as noted above, fixing stage has manifestly not been completed. As such, the builder had no entitlement to demand full payment of the fixing stage progress claim and no entitlement to suspend the works until payment was made. Now, if I inspect the property after it's been signed off by the building surveyor, and we find non-compliant works, we find defective works, and sometimes works not as per the plans. I'm talking about engineering. I'm talking about the truss plant layout, everything. It's not done as per that. Yeah, and then they get this. They get the invoice saying you got to pay us, man. The thing's done now, but we've got a report stating that it's not complete. And then if we go to Section 8 of the Building Contracts Act, Section 8, implied warranties concerning all the building work. And this is the question. I want to read this clause out, and then I want to ask you something. It says here, the builder warrants that the work will be carried out in a proper and workmanlike manner and in accordance with plans and specifications set in the contract. So now that we know what our rights are here as a homeowner, that, hey, look, I've actually got there's actually a warranty clause right there, and you've sent me an invoice saying that the frame stage is complete. You've got your building surveyor saying it's compliant, but then I've got something with evidence that it's not compliant. So should the homeowner pay that stage? Or, I mean, obviously he's going to need legal advice first, but they should know that, hey man, something's not right here, because there is something saying here that it's I have a right to actually not pay. Yeah,
well, see, part of the problem here is as well is that the only, I guess, compulsory checking that happens throughout, I guess, the build is the surveyor that needs to be appointed by the owner, right? So that's in the act, so that's in the law as well. So the owner appoints a surveyor. The surveyor will come, say, a minimum of 3 times, but probably between 4 to 5 for your standard townhouse. Now, they will check for compliance. You know, they're not going to check quality. You know what I mean? So a lot of the things that say, you know, your reports might find, you know, are compliance, yes, but also quality checks. So like a lot of the defects are not going to be picked up by the actual surveyor. You know, and so...
Oh, believe me, they do miss compliance.
Oh, well, they probably...
you've seen from my videos. Non-compliant works everywhere.
Yeah, well, like there's no guarantee they're going to
so really that's why it's so important to get this second, you know, report.
Yeah, exactly. Yeah, and so, you know, to get an actual expert that is independent, you know, to do, I guess, the defect checks and all that sort of thing, which is, I guess, quality checks is what you would fall under. You know, that's not really that's not happening unless the owner goes out of their way to actually get someone to really do that. And with these implied warranties in Section 8, this is, I mean, they've even said implied warranties, right? So that means that a lot of these contracts that you sign will have these actual listed as well. Because like say in the master's contract, it's, you know, it generally has it that says that the builder says that they will do the work in accordance with, you know, these standards. But even if it doesn't say it, like it is implied to...
So basically, it does apply even though it's not in the contract, yeah?
It should apply even if it's on the contract, if it meets the actual definition of what a domestic building work is, right? So, yes, and so these are there for a reason, and so, you know, there are cases that are brought like on these particular subsections, right? So in Section 8, you know, if you were to bring a claim, you know, say in a VCAT, you know, your statement of claim would say that there were breaches of these certain things, you know, so things like, you know, reasonable care and skill were not done, you know.
Reasonable, and even
work-like manner, you know, the work was not done in a proper work-like manner, things like that. So these are standards that are your minimum. That, you know, work has got to be done in accordance.
So basically, even if the homeowner, let's just say the homeowner doesn't want to get a building inspector or whatever, and then they can see, you know, something that has not been done with reasonable care and skill as per Section 8, subsection D, and there'll be an extract on the screen. The builder warrants that the work will be carried out with reasonable care and skill and will be completed by the date. But the thing is, reasonable care and skill. So if somebody like lays tiles and there's freaking steps everywhere on it, stuff that doesn't look right, they have a case basically.
Well, they can have a case, and the thing is, like, if you don't have that expert evidence there, like, how do you show that is reasonable care or whatever it is? Because it's one word against the other. It's just like an opinion, you know, and it, you know, and sometimes it could be biased as well. So you need certain experts at certain points.
We'll jump to another section now of this Building Contracts Act, Section 26. Builder must supply copies of relevant reports. This one here, And most of the inspections that I do, the homeowners say that, oh, the builder's not giving me the reports from the building surveyor. They're not giving me the plans, the structural drawings, nothing like that. And if I read this section, it says a builder must give to a building owner a copy of any report, notice, order, or other document that the builder is given in relation to the building work being carried out by the builder for the building owner by any public statutory authority. Now, it says here there's 20 penalty units, which is $3,846 if they don't think else. So, I mean, obviously they're not going to exercise this right, but the thing is, they do have, the builder has to give the owner some of the reports, because most of them don't even give it. And I just wanted to point that out there that, for the average homeowner, man, you have a right under this section. You could probably just print screen and send it to the builder, man.
Well, it's really a good idea, because to build a house or to build a dwelling or whatever, it's a big feat. It's not something, it's not for the faint-hearted, it's really difficult. And a lot of people, I guess, just have a lot of trust in the certain experts that they're going to get. And it really, is really helpful if they were to read an act like this, to see, just to sort of breeze over it and see what are some standard rules, and they don't have to go through the cases, or they don't have to get a lawyer or anything at certain points. But, say before the contract is done, you should get the right advice. And if there's issues, or if you wanted that peace of mind to get a certain check done during certain stages, it is really good to do that as well. But you should read these acts to sort of see like how the whole thing works, and what your rights are, what the builder's rights are, like what the rules are, and what we expect going forward. Because if you know what to expect, then you might minimize the actual a conflict that you might have with the builders or the trades or whatever it is, because you've got that background,
and that's why I love going through this document and highlighting this. These are the most common things that we see on site. Another one, which another section that I want to go through, section 37, variation of plans or specifications by builder. Now, we've got a court case here to back that up, but the thing is, subsection 1 of this section says a builder who wishes to vary the plans, specifications set up by the contract must give the building owner a notice, and there's 5 items that has to be on that notice. It says describe the variation, state why the builder wishes to make the variation, states what effect the variation will have on the work, and if the variation will result in any delays, and set the cost as well. But the thing is, this is so important, because we've got a court case here that we want to jump onto it. Console versus MLE Homes. Straight away, we'll go here, and I'll go to. So this case is such a good case, because it encapsulates a lot of breaches. But the thing is, what's interesting about this one, and I wanted to tell you, even though this builder right here didn't give this notice, he just did the variation, saying no, we talked about it before we signed the contract, whatever, and there was a bit of back and forth. It's how many documents? It's like 51 pages, this case. But this is what the judge did. They go, the member. I consider it will cause significant hardship to the builder if he was not entitled to claim the variation extra charge. And I consider it is not unfair that the owner bear the extra charge. The thing is, these guys had to go to court to discuss this variation breach. But to avoid that, just got to make sure that
that's right.
The builder will save a lot of headache, man. You got a variation, bro. Get this notice done. Just write it down as per this act. That way, if you want to go to court, mate, I've got everything in writing. It's black and white. That's it. But this guy, they left it to the discretion of the member.
Correct. Yeah.
And the member could have said, "Nah, mate, sorry, the variation is void because it didn't follow the act." What do you think of that?
Yeah, it's a really good point, and it just goes to show that you don't know what can really happen. If it goes to VCAT,
it's not guaranteed.
Nothing's guaranteed. Everything is on a case-by-case basis. And in this case, the actual sum that the builder was wanting wasn't all that much as well. So that might have been a factor in it too, there's, when they sort of try to balance this up, they're trying to think of like what's the hardship on one against the other and that sort of thing. That might have been a factor as well.
The builder went bust after this, man. $200,000 and
Yeah, but I mean, look, if you look at this particular section here that you pointed out in 37,
Yep.
if you go to subsection 2, it says here in subsection
go to it
2A
now. 2A,
that,
yep.
a signed consent, should be done or, and there's other exceptions. And so the builder can rely on the other exceptions, on things like if it was to do with things outside of the builder's control, if there was some sort of a notice.
It's good to talk about that 100%. Yeah, there is some sections out there. So in that same section 37, there's a subsection 2. A builder must not give effect to any variation unless there's a couple of other points there. Did you want to talk about those points?
Yeah. So so if the work was done because of factors that were beyond the builder's control, if the builder had included a copy of the building notice or the order in the notice that is required by subsection 1, and if the owner does not advise the builder in writing within 5 business days of receiving the notice that the building owner wishes to dispute the notice or the order. So I mean, this is not an exhaustive factor list of sort of what they might consider. I mean, if the owner's gone to Rio, for like a holiday or something, it's like how they're gonna dispute these things if
if the builder issues this notice, the builder issues this notice, he's done it, and the homeowner that doesn't reply to it, doesn't say nothing within 5 days, it gets accepted.
Potentially, I mean, look,
potentially gets accepted.
There's also like an exception with, I mean, if you go to subsection BI, is that or 1 is that the surveyor, gives a building notice as well. So there's a lot of things that have to line up, but to cover yourself and for communication and because it's one good thing to say, yes, these are your rights if you go to court, if you go to VCAT or something, but you know where you want to get there. You know what I mean? Like this is, we're here to tell clients that these are some things that you could do to sort of minimize your own exposure into not having to be in a position where you got to fight and you got to like argue with lawyers and this sort of thing to go go forward. So these are this is what the Act says, but as you saw in this case, that's just one example where the builder actually got the variation. You know what I mean? So.
Well, look, I've got two more sections here. I mean, there's so many things I want to talk about, but we're running out of time. But the thing is, there's 2 more sections I want to talk about, which is very, very important. When a builder, when there's a contract out there, and I've got a contract here, and I'll put an extract on the screen what it is. But the thing is, there is stages of for progress payments for when the builder should issue invoices. There's a base stage, frame stage, lockup stage, fixing stage, and most of the time, it's like 100% of the time, it's actually written in the contract what each stage is, and the amount of how much you should claim under the contract. Now, there's method A and method B, but the thing is, if a builder asks, let's bring this up. I want to bring this contract up. I'll just read it out for you because I don't think you got a copy of it here. We've got lockup stage. So this builder, this is what he's written, and you got to be careful, guys. The homeowner's external wall cladding and roof covering is substantially fixed. The subfloor is laid, external windows are fixed, or a curious quote to enter the home, whatever. But the thing is here, it says, and this is not inside the Act, I haven't seen anything in the Act that says this, substantially fixed. So if the lockup stage roof covering and cladding is substantially fixed, like this is asking for trouble, because let's just say it's halfway done. Is that substantially fixed? Or like, how do we know what substantial is? And that's asking for trouble, because if you go back to the Act, it does state here what a fixing stage is, for example. Lockup stage. We're talking about lockup stage now, yeah? So lockup stage means when the home's external wall cladding and roof coverings is fixed, the flooring is laid, and external doors and external windows are fixed, even if their doors and windows are only temporary. Now, this is what the Act says, but this builder has added the word substantial to the whole thing, which stuffs the whole thing up. And we're talking about 35%, which is $184,000.
Yeah.
Like if this guy goes, oh man, lucky I got this clause in, I'm gonna, Going to go bust soon, so I might as well invoice now. I can get it. I can get the money now. I know. Look, they probably put this in for cash flow because it's hard at the moment.
Yep.
But the thing is, if the homeowner and the builder are not on good terms or like there's no trust there, there's going to be disputes here. So make sure you define. What do you think the homeowner should do if it sees this clause inside the contract?
You mean before they've signed it?
Yeah, as they're signing it. Yeah.
The term substantial comes up a fair bit in these contracts, even with the standard form one. So like a substantial breach, a substantially completed or whatever, it could be. So, it's really challenging to, I guess, tell clients now just, just as a general sweeping statement as to sort of what they could do. But, they probably should get some legal advice before signing
that's what I'm saying.
You know what I mean? So
because they come to us and because this is from a job that we've done. We went there and it was at that particular stage. And we went there, we're like, man, lock up, like they're leaving it to us. Is this substantially completed? How do I know?
Yeah.
I mean, look, we'll see for incomplete works, no problem. And then we'll see non-compliant works, defects, whatever.
Yeah.
But how do I know what substantial is? Like these guys now got an invoice for lockup stage and now everybody's stuck.
Yeah. Exactly.
So it's so bad.
It just halts everything. You know what I mean?
So that's why they should get their contracts checked by, obviously, a lawyer. To see, hey man, there's something going on here, and the owner probably missed that. They didn't even see it.
They might have missed it. Exactly right.
You know?
And if special conditions need to be added to the contract, you can do that and that sort of thing. So, you definitely should, I guess, be doing your checks before you go into a major building contract. You know what I mean?
So that's why Section 40. If you want to know the stages of what they mean exactly, Section 40 limits on progress payments of the Domestic Building Contracts Act 1995. It's a free document. There'll be also a link for you guys to see. Now, the last one I want to... this is my favorite one. Section 42. When work is to be considered to have been completed. All right, cool. Now, this section right here, if you haven't seen my video for the body cam footage, it's number one out of the top 5. And the builder goes, so the builder denied access to, didn't want to hand over the job. No keys. They changed the PIN code for the front door, everything like that. No OC permit. I'm not going to give you the OC permit, anything like that, until you pay the money. I said, mate, I said to the lady, the builder, DBU builder, who was issued a license by the VBA, when work is to be considered to have been completed, a builder must not demand final payment under major domestic building contract until the work carried out under the contract has been completed in accordance with plans and specifications. So we'll just stay on this bit, on this section for a bit here. What do you think this means? Can this include non-compliant works?
That is, it just depends on the contract and plan. It would it depend on the plans and the specs, right? So if those defects are in a contradiction with the plans and the specifications, well, there is an argument there to say that
Well, for sure, because on the plans, most of the plans that I see, it does state that make sure you do the roofing works as per AS 3500.3. Make sure you do the waterproofing work as per AS 3740. AS 3740. It does state that, and if there is something inside the job that doesn't comply to that standard, it should tie back to not as per the drawings. I mean, that's what I will look at it. Potentially,
that's a common sense. That's a common sense way. That's the logical pathway of looking at it. But it just
need
depends on what the documents
you got to get legal advice. But there is a chance that if you have non-compliant works, that this clause is that they can't issue a final stage payment. You're not allowed to do that. I mean, there is that there's the gateway. The gateway. And then we go to subsection B. The building owner is given either. So first of all, the works have to be completed as per plans. This is number one.
That's the first limb.
Second one is that a copy of the OC permit, the occupancy permit under the Building Act, must be given to the owner, and in any other case, copy of certificate of final inspection. So when you finish, you can't issue the final payment, and also the OC permit has to be issued as well. You got to give it to them.
Exactly. It's not a contingent based on the actual payment being made. You know what I mean? So you can't hold it at a ransom.
Yeah, and even if this clause right here is not in the contract, that still applies.
Oh, yes, exactly. Yes, this supersedes what it may say in the contract. Yeah.
So this is why, I mean, a lot of people don't know about this. Like this particular builder didn't even know about this because I go, did you know you're not allowed to do that? You can't use the OC permit.
Yeah.
And even the plumbers, they have to give
the compliance document
within, I forgot how many days, but.
So it's $750 worth of work, including materials. You need to give a compliance document. Within
5 days or 7 days, something like that.
There. Yeah, I think so. Yeah, it doesn't have to be on the day, I don't think, but it has to be quite soon afterwards. But it's the same thing. It's the same sort of methodology, isn't it? Yeah.
But the thing is, they don't have to pay the bill. I'm saying, like if they pay the bill or don't pay the bill for the plumber. They still have to give that certificate, isn't it?
Well, yes, because the Building Act says that it's actually an offence.
Yeah.
To not give that document. Yes, exactly right. And it's under the Building Act.
Well, in this year, the Building Contracts Act, it does state that when work is to be considered to have been completed, he must not demand final payment until the work's been carried out and they're given the OC permit. Like, this is such an important section right here for homeowners to know that, definitely, man, don't pay it unless you're happy for it. I mean, the builder's going to hate me, but I mean, you're going to be in breach, and it might be penalties, man.
Yes, I mean, it's an entitlement of the actual owner, you know, and definitely. So, like, this is definitely like an important section for like owners to know as they're progressing through the build. To know this is like a really, really special, I guess, section here. Yeah, definitely.
All right. Is there anything else you wanted to add?
Not really, actually. I just want to thank you for your time.
No, I appreciate you coming, man. And I'll put Dean's detail in the description, all that, guys. And also, our next guest is going to be from the Australian Glass Window Association, and we're going to basically interview the guys about the importing windows from overseas, compliance of glazing, and what you should watch out for. So until next time, guys, let's go.